A man walks into immigration court with every document he owns stuffed into a manila folder, hands shaking, eyes scanning the room. He has been waiting 3 years for this moment. 3 years of renewals, of legal fees, of sleeping with one eye open. And today, a clerk hands him a piece of paper that says his hearing has been rescheduled. Again, not in 3 months, in 3 years. That sound you just heard, that hollow thud in your chest, that is the sound of the immigration court backlog. And right now, it is not slowing down. It is accelerating. This crisis didn't build overnight. It unfolded across years of compounding pressure. Pressure that could suspend your legal status. Pressure that could separate you from your family. Pressure that could force you onto a deportation flight before a judge ever hears your name. One wrong move in this system, and you disappear into it. What the federal government is now confronting is a caseload that immigration attorneys, judges, and policy analysts describe as structurally broken. And when that structure cracks under its own weight, enforcement does not pause and wait. It accelerates. Most people assume that a backlog means delay, and delay means safety. That is the trap. Today, you are going to understand exactly why that assumption is wrong and what it means for you right now. For years now, there had been signals, not from official press releases, not from formal congressional testimony, just signals that the immigration court system was approaching a breaking point no one wanted to name out loud. The Executive Office for Immigration Review, the agency inside the Department of Justice that oversees all immigration courts, had been struggling with a caseload that grew faster than its infrastructure could absorb. Judges were being assigned hundreds of cases per month. Interpreters were stretched across multiple jurisdictions simultaneously. Courtrooms were operating on borrowed time and borrowed space. The system had been overcrowded, yes, but also fragile in that overcrowding. The cases moved in waves, in surges, almost in tidal patterns. But what triggered alarm inside the legal community this cycle was that the wave did not recede. Immigration attorneys who monitor court scheduling systems recognize the indicators. The multi-year continuances stacking on top of each other. The sudden closure of individual hearing calendars in high-volume cities. The administrative judges quietly reassigned to handle asylum-only dockets. The sudden disappearance of available hearing dates in some jurisdictions stretching beyond 2027. And when the calendar goes dark that far out, something loud is already happening on the other end of the system. Early in 2025, court monitoring organizations documented what they described as a structural inversion in the immigration court pipeline, including case termination rates not seen in over a decade. These are actions a system under pressure only takes when it is signaling a specific kind of failure. Cases being administratively closed without decision, cases being dismissed for lack of prosecutorial resources, then quietly reopened, or cases being fast-tracked under emergency docket protocols that bypass normal scheduling entirely. Observers inside the legal community were not always sure which signal applied to which jurisdiction, or whether all three patterns were colliding at once in the same court. But one thing was unmistakably clear. The system was changing its posture, and when that happens without a public announcement, enforcement agencies pay close attention, because a congested court system is not a barrier to deportation. It is, under the right policy conditions, a gateway. The update issued by enforcement officials this year was not routine paperwork. It was not a symbolic administrative shift. It was a directive. Source after source within immigration law circles described the operational posture emerging from ICE as accelerated, coordinated, and most importantly, decoupled from court timelines in ways that are legally contested but operationally active. The argument being made at the enforcement level is procedural efficiency, but strategy only works if the other side, if you, hesitates and waits. The legal community did not hesitate. Their response was among the most coordinated mobilizations of pro bono immigration representation seen in recent years, with legal aid organizations, law school clinics, and nonprofit immigration firms all scaling intake operations simultaneously. But they cannot reach everyone, and that is exactly the gap you need to understand. Today, multiple immigration law sources confirmed that enforcement agencies launched targeted removal operations aimed at individuals with final orders of removal, including people who had recently received continuances and people whose cases had been administratively closed for what analysts believe was docket management rather than legal resolution. They moved before those individuals could file motions to reopen. They targeted people with expired voluntary departure orders. They targeted individuals in limbo between appeals and new filings. attacks. They targeted households connected to active deportation cases, including lawful residents caught in the same address record. This was not symbolic enforcement. It was calendar-aware enforcement. And that is what makes the backlog crisis so dangerous to misread. The backlog does not protect you. In certain conditions, it exposes you. Here is what most people misunderstand about a court backlog at this scale. When a court is overwhelmed, it does not treat all cases equally in the chaos. Cases with final orders of removal, meaning a judge already ruled against the person, are not in the backlog. They are already past it. Those individuals are already eligible for deportation. The backlog affects new filings, pending hearings, and appeals. It does not stop ICE from executing removal orders that already exist. Right now, there are an estimated 3 to 4 million cases pending in the immigration court system. That number includes people who have been waiting for initial hearings for years, but inside that number, there is a subset, estimated in the hundreds of thousands, with final removal orders who are still present in the country because enforcement resources were not previously prioritized toward them. That prioritization is changing. The current enforcement posture is specifically identifying and operationalizing those final order cases. This means that if you or someone in your family received a removal order, even years ago, even if you believed it was old or forgotten or superseded, that order is now an active target. Do not assume silence from the system means safety. Silence from the court docket and silence from ICE are not the same thing. One of the most critical developments in this crisis involves what immigration attorneys are calling ghost dockets. Cases that were administratively closed during previous administrations as a management tool and are now being reopened en masse. When a case is administratively closed, it does not disappear. It sits in a suspended state. The person involved often moves on. They find work, they have children, they build a life, they stop checking. And then, without a new hearing notice reaching them in time, because addresses change, because mail gets lost, because the system does not always track correctly, a judge can issue a new removal order in absentia. In absentia means you were not there, and a removal order issued in absentia is just as valid as one issued in a full hearing. This is how people with deep roots in the United States end up on deportation lists they never knew existed. This is the hidden layer of the backlog crisis that receives almost no media coverage. It is not just about waiting too long. It is about being removed from a process you did not know had restarted. If your case was administratively closed at any point in the last 10 years, you need to verify its current status immediately. Do not wait for a notice in the mail. Do not assume your attorney from years ago is still monitoring it. Go to the EOIR Automated Case Status Hotline. Call 1-800-898-7180. Enter your alien registration number. Verify where your case actually stands today. For families navigating this moment, the risk is not just to the person with the pending case. Mixed status families, households where one member has legal status and another does not, are facing a compounding exposure right now. Enforcement operations targeting one individual have, in documented cases, resulted in the detention of bystanders who could not immediately establish their own status during an encounter. This is not hypothetical. This is happening. If you have family members whose documentation is not current or whose status is unclear, the time to get clarity is not after an encounter. It is before one. Legal consultations, even brief ones, create a record of due diligence that can matter in a motion to reopen or a request for emergency stay of removal. For those in active proceedings, there are procedural protections that can slow or interrupt a removal, but they must be invoked correctly and on time. A motion to continue, a motion to reopen based on changed country conditions, a request for prosecutorial discretion, an emergency stay filed with the Board of Immigration Appeals. Each of these tools exists. Each of them requires documentation, timing, and in most cases, legal representation to execute effectively. Free and low-cost immigration legal services are available through AILA's referral network, through clinic, through local legal aid organizations, and through law school immigration clinics in most major cities. These are not second-tier options. Many of the attorneys working in these settings are among the most experienced immigration practitioners in the country. The system is overwhelmed. Enforcement is accelerating. But the law has not changed in the ways that matter most to you in this moment. The right to counsel in immigration proceedings, though not government-appointed counsel, still exists. The right to appeal a removal order still exists. The right to apply for protection under the Convention Against Torture still exists. The right to request a bond hearing still exists. These rights do not disappear in a crisis. They become more important in one. As this crisis continues, more data will emerge about just how deep the backlog truly runs and how enforcement agencies are prioritizing within it. But one thing is already clear. Understanding how this system works does not make you a criminal. It makes you prepared. It means you know which phone number to call before an agent knocks on your door. It means you know to check your case status before the system checks it for you. It means you are protecting your family with information, not with luck. Share this video with every person in your life who is navigating the immigration system right now. It might be the most important thing they see this year. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of this crisis unfolds.